Welcome to CRJ 134. This week we're taking a look at Chapter 15, which explores the juvenile court process. And the chapter really opens with a discussion of the juvenile court and its jurisdiction. And something important to remember is that each year there are between 1.5 and 2 million delinquency cases that are referred to juvenile court. Now, the key players in juvenile court are the prosecutors, judges, and defense attorneys. In many respects, the role of the juvenile defense attorney is really similar to that in adult criminal and civil cases. Now, both the attorney-juvenile relationship and the attorney competence are important. So to satisfy the requirement that indigent children or children who can't afford attorneys are provided with counsel, the federal government and states have really expanded public defender services. You may actually be surprised to learn that many juveniles still go to court unrepresented or with an overworked lawyer who might provide inadequate representation. Many juvenile court defense lawyers work on more than 500 cases each year, and more than half leave their jobs in under 2 years. Why do you think that happens? Now, the other side of that, the juvenile prosecutors, they are responsible for bringing the state's case against the accused juvenile. Ordinarily, the prosecutor is a staff member of the prosecuting attorney's office. And for the first 60 years of its existence, the juvenile court did not even include a prosecutor because the concept of the adversary process was seen as inconsistent with the philosophy of treatment. So in other words, the juvenile court was thought to be more rehabilitative in nature, not punitive. Now, even with the expanded role of the prosecutor, the juvenile court judge is still the central character in a court of juvenile or family law. Now, their responsibilities have become more extensive and complex in recent years. As well, they do have extensive influence over the agencies of the court, which means that juvenile court judges exercise considerable leadership in trying to provide and develop solutions to juvenile justice problems. Now, when you think about juvenile court judge, what are some of the qualifications that you would like to see, or do you think are necessary to make a qualified judge? Now, children who are neglected and dependent runaways and those who are homeless may be placed in secure detention facilities until a more suitable placement can be found. How do you feel about housing them in the same facility with people who have committed felony-type crimes? Is there anything that can be done about that problem? Now, a significant problem in juvenile justice also is placing youth in adult jails. And really, until a few years ago, it was a fairly common practice. There has been a lot of debate over whether the initiative to remove juveniles from adult jails has really succeeded. A lot of indications are that the number of youths being held in adult facilities has declined significantly. So a question to you is, do you think it's dangerous or even wrong to place youths in adult jails? Now, when we talk about intake, it really refers to the screening of cases by the juvenile court system. Now, one of the most important alternatives chosen at intake is what we would call non-judicial disposition, including diversion programs. And those have really been created to remove non-serious offenders from the juvenile justice system, provide them with more non-punitive treatment services, and then help them avoid the stigma of a delinquent label. Now, there are a few juvenile codes that require guilty or non-guilty plea when a petition is filed against a child. In most jurisdictions, an initial hearing is held at which the child either submits to a finding of the fact or denies the petition. If a child admits to the facts, then the court will determine an appropriate disposition. If the child denies the allegations, then the case will proceed to trial. A high percentage of juvenile offenders do enter guilty pleas, just like in the adult system. It isn't really known how many of those guilty pleas, though, do involve plea bargaining. And so consequently, there's been a debate over the appropriateness of plea bargaining in the juvenile justice system. So think for a minute on whether or not you think juveniles are capable of making those decisions, even when they're assisted by an attorney, and should it even be an option for them? Now, one of the most significant actions that can occur in the early court processing of a juvenile offender is what we'd call the transfer or waiver process. All states allow juveniles to be tried as adults in criminal courts in one of 3 different ways, whether it's concurrent jurisdiction, statutory exclusion, or judicial waiver. Now, the standards for transfer procedures are set by state statutes, so they differ from state to state. And so it's important to look at what is your state requirements. Now, in addition to mandating state juvenile code requirements, the Supreme Court has mandated the application of constitutional due process standards to the juvenile trial. For many years, children were really deprived of these rights because the parens patriae philosophy really governed the relationship to the juvenile justice system. Now, most states allow the judge to select whatever disposition seems to be best suited to the child's needs, which could include institutionalization or going to a secure detention facility. Research does show that probation really is the kind of the disposition of choice, even in the most serious cases. And do you think that that's a fair disposition in serious cases? Now, next time we'll take a look at the last chapter in the book, which is chapter 16, and it will explore juvenile corrections.